I'm former prosecutor Neil Shouse, and I'm here with former police officer Michael Scafiddi. We're both now criminal defense attorneys. And Mike, today I want to ask you about this crime of battery with serious bodily injury. So Penal Code 243D. What is it? I mean, what sorts of things would cause someone to get charged with this?
From a practical standpoint, Neil, think of a bar fight. Punching someone in the face, knocking them down to the ground. They sustain a concussion, a fractured eye, a black eye, contusions. You kick them while they're down, or a kick in the groin where there's a testicular injury, things like that. Think about an unlawful touching, a fight, where someone has a significant injury. Something not minor, more than minor, as I just described.
So let's say they've got some redness, a bruise, a little welt. I mean, where is the line between something that's not a serious bodily injury versus serious bodily injury?
Well, I can tell you, it's not a bright line. Generally, a little welt probably won't do it. A little redness won't do it. But there have been cases where a blackened eye can do it. Certainly a concussion, even a minor concussion. Sore ribs, fractured ribs, abrasions, welts where they'll come up in a couple inches. You have swollen.
Cuts, lacerations.
You're always going to see.
Broken chipped teeth.
Chipped tooth. You're always going to see those allegations. And because technically those types of injuries do meet the requirements under the code as a serious injury.
Now, if you got convicted of this crime, battery with serious bodily injury, what are you looking at in terms of penalties?
Well, if you get convicted of a felony battery with serious bodily injury, you can go to state prison. It actually could be a state prison case.
For years?
For years. It's a serious crime. It is a serious offense.
What about is it a strike under California three strikes law?
Well, if it's a great bodily injury, if there's a significant injury, it is. It's a strike under California law, which makes it a presumptive prison case.
Now, I know, Mike, over the years, you've had a lot of success in defending clients who are charged with this, battery with serious bodily injury. What are some typical defenses or ways that you found to sort of help your clients get out of it?
Self-defense. Defense of others. Something's going on. You're being unlawfully attacked. You have a right under California law to defend yourself.
You're in a fight. This guy's coming at you. This guy's attacking you. And maybe you do injure the person, but you do it in self-defense.
Exactly. That's a total defense to a 243D, as is defense of others. I don't have to sit by idly while I watch someone being beat up. I can go in under California law to defend that person.
Protect your friend, protect your family.
To protect friends and family.
Protect a bystander.
Protect the innocent citizen. The person walking down the street who's attacked by some deranged maniac. We have a right to go to their defense. And
what about mistaken ID? I know you've had a lot of success in these cases asserting sort of a mistaken identification defense. Tell me about that.
Typically, and we've had a lot of cases like this, bar fight. People have been drinking. It's dark. It's not brightly lit up. People dress similarly. They're the same ages, same physical size. People's judgment are impaired. Their eyesight's impaired because of intoxication levels.
It's a chaotic situation. Punches are coming everywhere. Bottles are being thrown everywhere.
Just like you see on TV. Just like you see on TV. It's crazy. Bar fight in the movies. And it's hard to identify who did it because it happens like that. I mean, it's instantaneous. And oftentimes, the wrong person will be ID'd. And so in those situations, a defense is mistaken identity.
And ultimately, I mean, the prosecutor has to prove in court, let's say it is a bar fight like this, and let's say someone's hit with a bottle. The prosecutor has to prove beyond a reasonable doubt that your client is the one that threw the bottle. And I mean, if there's reasonable doubt about that because of this chaotic situation, then they deserve to be acquitted.
Oh, I agree with that. And some of the other defenses, an exact situation that you just spoke of, is there any video in the bar that shows our client wasn't the one who threw the bottle? We had a case like that we prevailed on.
Third-party witnesses. Sometimes you get witnesses. You have 5 witnesses, and every one of them has a different recollection of what happened.
Exactly.
And you don't know who to believe.
It makes it very difficult for the district attorney to successfully prosecute that case. It's a very difficult proposition. Any chaotic scene, it's going to make it more difficult for a prosecutor to present evidence with surety to the jury.
So let me ask you this. I mean, suppose that the evidence is pretty overwhelming that your client did commit the battery with serious bodily injury and maybe confessed to it and it wasn't really self-defense. are there things still that you can do to try to make the case better for your client?
We can, Neil. And what we call that is our mitigation portion of how we attack these cases. For example, in the police report, it indicates that the victim suffered certain injuries. What we'll do is we'll get that person's medical record so that we're not just taking the word of a bystander that someone was injured. We'll find out what the medical diagnosis was, what the treatment was. Oftentimes that'll lead to the fact that while the person suffered an injury, it wasn't as great as originally believed. So we'll have that, we'll present that to the district attorney.
And sometimes, I mean, the alleged victim or the victim has an incentive to sort of embellish their injuries. Maybe they're trying to win a civil suit or get victim restitution. So I mean, oftentimes they should not just be taken at their word.
Oh, I agree with that. In fact, we'll go in, we'll have our investigator contact that person, find out what their real damages are. When I mean by that, what's their out-of-pocket expense? Did they miss work? Did they have out-of-pocket medical bills? And we'll offer restitution to them and then show the district attorney that restitution has already been contemplated. We're prepared to do it immediately upon the agreement or upon sentencing. And that way show the district attorney that our client is trying to make the victim whole from a financial standpoint in that case. So that's another mitigating factor. And then the final mitigating factor is we let them know who our client is. We don't want them to view our client just in that one little moment in their life in a bar fight, but see them from the totality of their life as a husband, a father, a leader of their community, a person who works hard to support their family.
A human being with hopes and dreams and redeeming qualities.
Exactly. If we're all going to be measured by seconds of our life and not the totality of our life, then we're truly not understanding who we are as people.
So, oftentimes we have a very good person who's a productive member of the community, is a good family person, but just had a moment where they snapped. Perhaps they were drunk, perhaps there was some provocation, and so their whole life, like you say, shouldn't be judged in that 5 seconds where they snapped and did something out of character.
I agree wholeheartedly. We shouldn't turn someone's life upside down for one punch or one snapshot of their life.
And as serious as this crime is, and we talked about it, it can be a felony, you can go to prison for years, a strike, and people call us all the time who are in great despair when they're charged with this offense. The take-home message is that with a good criminal defense lawyer, it might well be possible to get the charges reduced or even dismissed.
Not only well possible, very likely. In my experience here, we've had great results for clients who in that first call, and it's always the first call, Neil, where there's hysterics. They're just overwhelmed. And we get them in, we start breaking down the case from all the defenses we can bring to learn about who our client is as a person so we can provide them the best defense.